A very good morning again, and thank you again for following up and clicking on our second part and our second feature on SCARP with Ian Barrett, Director of Restructuring at KPMG. Now, today, what we're going to do is we're going to focus on various questions that have come up in conversations I've had with clients of Atradius Collections, and basically they pose questions to me that will ultimately be on the ground type questions, the ones the sort of minutiae questions that I'd be keen, as I'm sure many others will be keen for Ian to answer. So I'm going to go on to that. Very good morning, by the way, Ian, again.
Morning, Michael, how are you keeping?
Not too bad. I'm going to have probably a few sort of what you would call curveball questions here for you. So hopefully you're prepped for it. These are the ones that are maybe people are sort of asking and going, what is the story here? What is the story there? But we'll get kicked off anyway. I suppose one that has jumped to mind is, what will the Revenue Commissioner's position be? From my personal reading about SCARP and just general chit-chat so far, a key issue that sort of seems to be arising regularly is to be that the revenue can opt out of this sort of plan and rescue plan if it's put to creditors. Could you sort of inform us really how that works? Because obviously this is critical with the revenue,
Yeah, that's right. There's certain liabilities though to the Revenue Commissioners and the Department of Social Protection also, that can be excluded from SCARP. So these creditors have the option to be excluded from a rescue plan that is proposed by the process advisor. So essentially, these creditors must notify the process advisor within 14 days of receiving notice from the process advisor of their appointment if it wishes to be excluded from the rescue plan. So Revenue or the department must have sufficient ground to opt out or to be excluded from the process, or from a rescue plan, I should say. So this clearly presents a challenge to formulating a rescue plan if it cannot agree a write-down of debt owing to these creditors. And it was recently stated in the DAL that warehouse tax debt of SMEs is around €1 billion, which is a significant sum, and obviously Revenue are going to play a significant part in SCARP because of that. So it will be important for companies to carefully consider proposals for Revenue and their likely preferential creditor status as a different class of creditor as part of a rescue plan. So I'm not aware of any official statement yet from Revenue or the Department of Social Protection, but Revenue do have a high participation rate in personal insolvency arrangements. So just hope Revenue will take a similar approach here.
And is it fair to say what your thoughts would be when it comes to cause these creditors to opt out of SCARP? Like, hypothetically, what would make a creditor go, no thanks, I'm opting out?
Yeah, I think the revenue tax compliance history is key. It's an obvious one, isn't it? So revenue support will probably be difficult to get if there is a history of late filing of tax returns, long-standing tax arrears, missed tax arrears, installment payments. Another example could be a poor tax audit outcome. So there's likely these state creditors will form part or all of a preferential class of creditors. So their cooperation or approval of a rescue plan is really greatly going to assist the successful exit from SCARP. So it is critical for the company to be up to date with its tax and statutory obligations. And as I said, Revenue will be very important in many SCARP, as they will typically act as a proxy holder of other state creditors. So their weighted vote on rescue plans is going to be quite high in many instances.
Another question that I was asked by a client of mine who's a landlord, who's obviously a commercial landlord, and key creditors like banks, landlords like him, they are watching this with real significant interest. How do you think SCARP may impact them and that sort of audience?
Yeah, that's true. That's right, and I think it will be all businesses directly impacted if they're customer, client, whoever enters SCARP. There will be a write-down of debt, as I said, from a successful SCARP. So impacted creditors, when deciding to support a rescue plan, need to consider if the SCARP outcome delivers a better return for them as opposed to liquidation, as we touched on earlier. So impacted creditors, will they be able to do business with the company into the future? The answer is no. if the company goes into liquidation. Okay, so there are wider commercial implications for creditors than just the proposed return they're going to get from a rescue plan. So process advisors, they need to have or will have the ability to go to court for the repudiation of leases or onerous contracts. That's obviously going to impact landlords, as you said. So landlords will need to consider their position carefully and seek professional advice on any rescue plans that they may be brought into. Like examinership, secured creditors will consider the potential outcome of enforcement, such as receivership instead of SCARP. They may potentially appoint a receiver to possibly continue to operate a business and sell it to maximise the value of their security. If a secured creditor appoints a receiver, a process advisor can apply to court for protection from enforcement action and for the receiver to cease their role from a specific date. So it's a critical role for a process advisor to demonstrate to all these types or classes of creditors that a successful SCARP is the best outcome for creditors that should lead, hopefully, to a sustained business relationship they can all benefit from.
Right. Okay. A view of examinership in the past has been sometimes something that in most circumstances a business does not enter the process because of one or even two major issues, whether it be hypothetically COVID-19 or major bad debt, etc. So some businesses, like for example, have entered examinership in the past because of poor management or over a long period of time. The approval of such processes have sort of ended up with the poor management continuing business, and they are sort of like at a competitive advantage sitting on reduced debts post examinership, if that makes sense. You know, the process itself could reward bad companies, from just my reading of your question and answer, at the expense of their suppliers, particularly as lenders are fully secured. So should IPs, insolvency practitioners, take this into account when putting forward and proposing various schemes, really?
Yeah, I think you will see viable businesses who have become insolvent due to COVID, and you're also going to see businesses who were already insolvent or were on the verge of insolvency pre-COVID, and both of these types of businesses will pursue SCARP. Okay, so the process advisor, like an examiner, will assess a company's future prospects, project the financial performance, determine if the company can return to profitability based on the proposed rescue plan. A board management's ability to improve a company's performance would certainly come into a process advisor's thinking when assessing the reasonableness, feasibility of a company's financial projections and whether it is a viable business into the future. I wouldn't agree that examinership generally rewards bad businesses. Like a company entering examinership needs to go through a process. It needs to go through a high court petition supported by an independent expert's report. It doesn't have an automatic right to enter examinership. It's always at the discretion of the judge hearing the application on whether a company can enter examinership or not. And there are examples of High Court judges refusing an application for examinership for various reasons, including challenges by certain creditors. And creditors concerned with a company's management or board have always been able to raise these issues with a court during the examinership process if they choose to do so. And again, there are examples where this has been considered by a court when issues are raised by creditors. In the case of SCARP, due to the minimal court involvement, it requires the process advisor to issue a report to the ODCE on how the process was conducted, and any concerns with the board of directors can be raised in the report to the ODCE. So it does come into the consideration of a process advisor.
Okay. Massive information and very detailed, and thank you very much for articulating a lot of specific questions, as I say, that have kind of gone through the various channels to myself. But I suppose the $64,000 question, the sort of gold medal question, the 64,000 answer we're all looking for, is why is SCARP so important, and how will it appeal to companies?
Yeah, it's I think if you look at it overall, I mean, it's been widely reported for the last 18 months or so, the damage COVID has been doing to businesses across various sectors, the economy in general. A lot of focus, understandably, has been on hospitality, tourism, certain elements of retail, but there are likely other sectors impacted also. And various experts, commentators believe that small and micro businesses are the most type of businesses impacted, okay? So many are going to need restructuring support of some shape or form, and SCARP will be a potential solution. So that's the importance of SCARP, really. And unfortunately, there are business owners who are saying they may never open again, or they've already decided not to open again. And hopefully this option will appeal to those business owners to at least explore, to take advice on the restructuring options and supports available. And insolvency professionals, whether it's your lawyer or your accountant, they'll be able to advise on businesses and what level of restructuring is required and how it can be achieved.
And I suppose for me, just to put it in layman's terms, and by the way, thank you very much for educating myself as well as obviously the audience. In layman's term, is I suppose to put a slogan to it, so to speak, everything is not lost. Then if companies are 12 million turnover or under are going through difficulties, this is now giving sort of a route out into a positive future. Is that a fair assessment? Yeah.
That's correct. Yeah, if they can meet the small and micro criteria under the Act, and they can at least explore the process anyway, and hopefully they'll be suitable, viable businesses that can come out the other side.
And you have, I would presume, you would have literature, Ian, available that will obviously summarise what we've discussed today. Obviously, we'll brief people on the various specific bullet points that we've discussed. I presume that's available there as required.
Yeah, no, absolutely. Yeah.
Okay, that's absolutely wonderful. I mean that sincerely. It is a big subject. It's one that it's in depth. I personally have read through, and knowing the intricacies is critical. And Ian, I really sincerely mean this. Thank you very much for finding the time to share that. I will, of course, send this. I will post this on various social media, and obviously make this available as and when required. I will put Ian's details also, obviously, in the post as well. And of course, if anybody contacts me about it, I will, of course, divert to Ian, our partners at KPMG. So listen, it's been an absolute joy to talk to you, Ian. I do hope that this will be first of many sort of added value pieces that we can do. I wish you a good day, and as I say, to repeat myself again, appreciate your time, appreciate the knowledge, and as I say, look forward to talking to you soon.